Hello, everybody. It is noon, so we are going to go ahead and get started. I'm sure some people will be hopping in here as we continue along, but we are going to get started because it is noon. My name is Jordan Walker. If we haven't spoke, which I presume for most of you haven't, I'm an attorney, and I am here today to talk to you guys about the Ameren Illinois Grid project. We'll get into that here in a bit. We're going to talk about what happens in this scenario when a utility company comes in and they need your property for a project. And we're going to be talking about a little bit about eminent domain. How do you negotiate what you're supposed to do? What happens? All sorts of good information. If you have questions as we move along, feel free to ask them in the chat box or in the Q&A box. I might not address them at that time, but we will definitely address it either in the presentation or at the end when we're done. So with that being said, I'm going to go ahead and share my PowerPoint. One second. Okay. Okay, with that being said, we'll go ahead and get started. Again, who we are, what we're doing today. I am an attorney. I work for the law firm of Seaver Story Walker. We are a eminent domain-based law firm. We are eminent domain only. We are landowner only. This is the only type of work that we currently practice as eminent domain, representing landowners such as yourself that are faced with acquisitions from municipalities, the DOT, and obviously utilities, including Ameren and other types of utility companies. As a quick, disclaimer for the rest of the presentation, we do not work for Ameren. We do not work with Ameren. I work for Seaver Story Law Firm, Seaver Story Walker Law Firm. We are adversarial to Ameren, meaning we are on the other side. Ameren has their own attorneys that they hire to go against you. You are obviously allowed to hire your own attorney to go against them. We are landowner attorneys. We have never worked for utility or energy or condemner like IDOT or otherwise. We've only been landowner, including against Ameren. And I just want to clarify that up front because some folks have contacted us already asking, who we are we with Ameren? A lot of people assume we're working for Ameren. We do not work for Ameren. We are here on behalf of landowners, should you choose to hire us. So I want to clarify that just at the top because a lot of people were confused, and that's fine. What we're going to be doing today, we're going to talk about the project, obviously what's happening. We're going to talk about eminent domain. We're going to talk about negotiating with Ameren, but most importantly, we're going to share our knowledge and experience. For a lot of you folks, I know not everybody, but for a lot of you folks, this may be your first foray into eminent domain, what happens when somebody can take your property. And so for those folks that aren't familiar with how this works or how it goes, we're here to relay our knowledge, what we know, what we've learned. And we have learned quite a bit. As I said earlier, this is the only area of law that we perform, that we practice. So we've learned quite a bit about how this process works in the state of Illinois and many other states for that matter. But for today, we're obviously just talking about Illinois. Included in that experience is experience against Ameren and against experience against utility companies, large groups of people. Some of you might be familiar with the Ameren Illinois Rivers Project. It came through, about 4 years ago, 4 or 5 years ago. We represented about 60 landowners on that project against Ameren. We currently represent other landowners against other utility companies in Illinois, in other states. And we'll talk about that experience here in a little bit as well. The long and short of it is that we've done this a lot. We know how Ameren operates. We know how utility companies operate. We know how the law, eminent domain law, plays into the entire process. And as a consequence, we know how this works. Our location, just real quick about our firm, and that's what I'm talking about presently, of course, is our firm's experience. We have offices in multiple states. In Illinois, our office is in Springfield. Our headquarters is in Indianapolis, but we also practice in several other states. Me personally, I am licensed in Indiana, Illinois, Georgia, and Texas. So But of course, today we're talking about Illinois. Our mission as a firm is to represent landowners in these eminent domain situations. There are not a lot of folks that do what we do. And if there are attorneys that do what we do, usually they do something else in addition to eminent domain. This is the only thing we do. It's the only type of law we practice. So that's our mission as a whole. Our mission today, though, is to educate landowners, educate you guys on what's going to happen, what to expect, what to do as Ameren seeks to acquire your land over the next year or so. So let's talk about the project real quick. So this is the project. Some of you, I've already spoken to some of you, and some of you have no idea what I was talking about. Most of you did know what I was talking about, but for those that don't, the Ameren Central Illinois Grid Transformation Project is a significant project that's going to be undertaken by Ameren with Ameren Transmission Company. And a 10,000-foot view, you can see there on the map what's going to happen. They are going to install or upgrade about 380 miles, about 400 miles of transmission line across the state. You can see it's in two segments, one further south towards near Quincy, north of St. Louis, of course, and then there's the northern route that extends across the entirety of the state, and that's the more substantial route. The long and short of what they're doing is they're trying to bring up these transmission lines up to I guess sufficiency, or they need to be upgraded to meet demand, and that demand includes increasing the voltage across the transmission lines. We'll talk about that here in a bit. But the purpose of the project is basically to upgrade existing facilities, build some new facilities. They'll include 3 new substations. There'll be upgrades to existing substations. There'll be power lines. There will be all sorts of various facilities that are being constructed as part of this project. But the long and short of it is that they are trying to upgrade these facilities to allow for more capacity on the lines. And these links at the bottom of this page, I think you'll find helpful. The first link, amerengridil.com. So this is Ameren's website. As it turns out, Ameren has a website, an interactive website that has a map that allows you to interact and effectively find your parcel. One question I get a lot is, what is Ameren doing to my property? Where are they going? Where is the path? Where's the corridor? We have these maps. That's how we mailed to you guys. That's how you got the letters. We're through these maps. However, Ameren itself has an interactive map, like I said, that you can go on this website and you can see if you can find your parcel, and it should show the path of the power line across your specific property. So if that's something you're interested in researching now, I would go, or today or whenever, write this website down, amerengridil.com. You can also go to the Ameren's website. If you Google the Ameren Grid Project or Illinois Central Illinois Comprehensive Grid Project, you'll find it. It'll take you to Ameren's website. On that website, you'll find this interactive website, this interactive map that you can find your parcel, see what they're doing, so that you know what their plans are. The second website, which is the Illinois Commerce Commission website, and it's right there below the grid website. That is a link to the docket. Now, in order for Ameren to build this project, just like any other utility company, they need to get approval from the Illinois Commerce Commission, the ICC, as it's referred to. They are currently in the process of doing that. And this is the docket number that they have identified. So if you go to this website, search that docket, you'll be able to see everything that Ameren is seeking approval for. This is all the information you could possibly need about this project. If you're looking for that, go to that website, search the docket, you'll find it. And then moving on to the timeline, this is also a timeline that was on Ameren's website. And you'll see in the grand scheme of things where we are, you'll see this red arrow, early 2024. This schedule is on track as far as we're aware. They filed their petition with the ICC. I just discussed that in order to get approval, they need to file a petition. They have filed that petition. And that's what I tell folks, when the petition's filed, that's when it becomes a real thing that needs to be considered, something you need to consider as a landowner, and prepare for. They filed their petition. They did so in February. So we're right here on the process. I've already talked to several folks who have offers. I would expect that if you are a landowner, if you received one of our letters, according to the documents that were filed by Ameren, you are one of these potential landowners. I would expect that if you haven't received an offer yet, you should receive one within the next year from Ameren. I would expect. Again, we don't work for Ameren. We don't have any insider knowledge. I wish we had that knowledge. We don't. We can only go by what's been publicly released. But I would expect offers to come in the next year if you are an affected landowner or an impacted landowner. And as you can see, the schedule right now is for the construction to begin 2 years from now, approximately. So 2 years from now is when we're looking at construction. And then according to this schedule, they intend on being done by 2029, with restoration concluded shortly thereafter. So that just kind of gives you a ballpark of what the schedule is for this project. Ultimately, the only important deadline for you is really the individual offer that's provided. You know, when they get approval by the Illinois Commerce Commission, what comes with that approval also is generally the eminent domain authority that I referred to previously. So it's expected, and it is fair to assume that the ICC will grant Ameren its eminent domain authority when and if it requests it, which it will do sometime during this ICC process. So the reason why I say that is that we have to assume that Ameren will have eminent domain authority. They will get it from the ICC. They always do, just like every other utility. They will get this authority, and then they will utilize it if necessary to acquire your property through eminent domain. But that can't happen until they get eminent domain authority. They don't have it. I would expect that they would get that sometime early next year, maybe late this year. So the takeaway from that is to assume that Ameren is an eminent domain entity that can take the property. What that means is that the negotiations between you and Ameren are not traditional negotiations like you're selling your property to your neighbor, because your neighbor can't just take your property. Ameren can and will be able to do that. And so it changes the leverage between you and Ameren. The introduction of this eminent domain component changes the negotiation power between the parties. So it's important to remember in all these things that, you know, ultimately Ameren will be able to take the property. We have to assume they'll be able to do that. And so approaching negotiations is a little different than your traditional negotiation. We'll talk about that though in a bit. What are they going to build? So this is pursuant to the petition that Ameren filed with the ICC for the 400 miles of upgraded or new line. There are 4 types of acquisitions that Ameren will be undertaking. They will be undertaking rebuild acquisitions. So this will be rebuilding existing lines that they own already on properties. There will be addition, where they'll be adding to existing lines that already exist on the property. There will be a new corridor type of acquisition, and this would be acquisitions where there is no power line on the property, and they're introducing a new power line and a new corridor to the area. So that's no pre-existing line, brand new line. That's a new corridor. And then replacement, as you might imagine, is replacing the existing line that may exist on the property. And this is relevant because the type of offer you receive will likely be contingent on what type of acquisition they're seeking from you. Each type of acquisition presents with it different challenges and different details and facets and nuance. So your acquisition might be different from your neighbor's acquisition, even though they're right next to each other. It's important to remember that everyone's property, you know, is different, and these acquisitions themselves will be different. So your case, even though it looks just like your neighbor's, might not be the same. And there's an endless number of differences that can exist between easement acquisitions. So back to what they're building. The goal of Ameren is to get all of their lines basically to 345 kV. That's 345,000 volts, or 345 kV. That is the amount of electricity, the capacity on the line. Most of the existing lines that Ameren has are 138 kV, so they are much less. And they'll be attempting to upgrade those to 345. In order to do that, it's either building a new line, upgrading existing, adding to existing, so on and so forth. But back to what they're building, most of the existing lines that they'll be upgrading have about 100 feet wide corridors. This is in accordance with the National Electric Safety Code (NESC). It requires 100-foot corridors. 345 kVs require 150 feet. So it's going to be bigger. If it's a new line, you're getting 150 feet of new easement. If you're getting an add-on, it'd be another 50 in all likelihood, just to give you an example. And what are they going to be building on this easement area in this corridor area? There will be steel monopoles. They'll be between 80 and 150 feet tall, and with about 7 to 8 structures a mile, 700 to 900 feet between the structures. So that gives you just kind of a rough description of what they're going to be building on the easement that they're going to seek from you. And we'll actually get exactly what that means now, and what is an easement. So again, what will they want from you? They will want an easement, and a lot of farmers landowners and farmers are already familiar with what easements are. They're fairly common. Easements are effectively the rights of certain entities to conduct certain activities in a certain area of a piece of property. So the most common type of easement is utility easement. So if you have water going to your house, if you have municipal water, if you have municipal utilities, not a lot of people do, but if you do, to run those utilities to your property, the utility companies will get easements. So if you want running water, you need an easement to have the pipe go to your house. And that means there's an easement on your property for that right to get the water and the right for them to run the water to you. That's the most common type of easement. Ameren is also seeking an easement. However, they are much different than the local municipal water easement that runs water, to your house, or gas to your house, or electricity to your house. These easements are much bigger. They are much more imposing on the land. As a landowner, you are relinquishing much more rights to the easement holder, and they are more valuable, therefore, to both you and the company seeking to acquire them. But beyond that, these are big structures, these are big acquisitions, and there are a lot of compensable components to it that are not considered in negotiations. And so this is not your traditional sale of an easement. It is effectively, as I put in the slide, you're essentially deeding an area of your property to Ameren, and that's how we look at it. You're effectively deeding the strip of land to Ameren to build the line. One of the questions I get a lot, is, will Ameren be allowed to do something on the easement? And that's, you name it. Will Ameren be allowed to access any part of the property? Will Ameren be allowed to do this? Will Ameren knock down my fences? Will Ameren open my gates and let my livestock out? All these things. I get the question from landowners: will utility company be allowed to do these certain activities on the easement? And my answer to that every single time is, it all depends on what the easement says. So the easement is going to describe very specifically what Ameren can do, and it should include what they can't do. And it's very important that what is negotiated is put into this easement, and in certain precautions, certain language is included in this easement to protect your rights and to prevent Ameren from getting more rights than maybe you'd like to relinquish. So when people ask me, is Ameren allowed to do this on the property? Is Ameren allowed to do that on the property? My response will be, just like it always is It depends on what the easement says. If the easement as read allows for Ameren to do something, they have the right to do it. So it's incredibly important to make sure these easements are drafted appropriately and accordingly. And I'll give you an example right now why that's important. First of all, what is told to you is not always what the easement says. And when I say what's told to you, I mean what is told to you by right-of-way agents that work for companies that Ameren hires. And we'll get into right-of-way agents here in a bit, but it's important to remember that what they tell you Ameren can and can't do means nothing. What matters is what the document says. Ameren's right-of-way promises, verbal promises that are made by their right-of-way agents, if they're not reflected in the easement, they mean nothing, because the easement is recorded with the county recorder's office, and that's the only document that will be on the record of this property moving forward. There will be no discussions of what Ameren right-of-way agents told you, what they promised you, or even what they put in an email. It needs to be in the easement for it to matter. And so it's important to remember that to not rely on what a right-of-way agent tells you is in the easement, but to actually read it yourself, get an expert to read it and review it and see what the problems are, if any. Here are some common pitfalls with an easement document, with easement language. And these are real life examples. These are real life examples from Ameren. You'll recall that we worked against Ameren. We have worked against Ameren quite a bit, and I've seen the types of easements that Ameren proposes to landowners. And needless to say, what they tell you is not necessarily what's in these documents. I have seen some very, very poor easements drafted by Ameren that landowners have signed, not reading it or not understanding it, and they featured these problems. Here are some issues that can arise from a poorly drafted easement. Unfettered access. This is fairly common. A lot of times, and as a matter of fact, Ameren's their boilerplate easement, or what they used to use as their boilerplate easement, allowed for basically access to the entirety of the parcel. So the right-of-way agent is going to come to you and say, we only need 2 acres or 3 acres or whatever. But what they're not going to tell you is that the easement itself actually applies to the entirety of the parcel. And not only that, it allows for unfettered access, meaning you assume, based on what you're told, that Ameren will access the line from adjacent landowners' properties or from public roadways. Now, that's what they'll tell you. But if it's not in the easement, what that would allow would be them to access the property however they'd like. Driving through the middle of fields, driving through the middle of farms, basically getting there however they'd like. What does that mean? Well, that means knocking down crops. That means bothering your privacy. Just driving out, doing God knows what out on the land, all over across the parcel. That's an example of a pitfall in an easement document. The second, access the entire parcel, not just the easement area. That's basically tied in with the first. Third, no clause for future damages and crop losses. So one thing I've seen is that they might offer some money up front for crop losses, but they might also include some language that basically says this is all you're getting. And even if 10 years from now we come in to fix the line for some reason, we knocked out a bunch of crops, or we run our trucks out there and compact the soil, or knock down a fence, or you name it. If there isn't something that says they're responsible for that, just like they're responsible for paying you up front, then they can do it. You don't get anything. So that's one clause also that can hurt people down the road. I've seen easements that fail to include terms for proper ground restoration, and this is a big deal, obviously, for rural properties. And we've seen it personally, because when they get out there and they start constructing these big lines, the soil gets compacted. They divide the soil between, or they don't divide the topsoil from the subsoil. They mix the subsoil together. They just throw it back in after digging up the land. And then you got subsoil mixed with topsoil. You have compacted soil. You have broken field tile. All of these things, and the land is not what it once was. And if the easement doesn't say that they need to return the ground to the proper condition, then they'll just leave it and they'll let you to deal with it. So that's that's a very important one that we see a lot. I've seen a lot of issues, especially if it, there have been, I don't need to tell Illinois farmers that the last couple of years have been a little tumultuous from a weather perspective. And if they come in and start building when it's when it's unprecedented rain again, and there's flooding, and they're driving in the slop, and they're messing up the land because they don't care, because they just want to build this line. And if they mess up your ground in the interim, and there's no easement language that requires them to come back in and restore it to a condition that you would prefer, then they're not going to do it. Ameren's in the business of making money, and they're not out here to do you any favors. So if they can cut corners and not have to come back to your property to fix anything, then they will. Another issue I've seen liability transfer to landowners for power line problems. It's important that there's a clause in your easement that says, hey, if anything happens with that power line, it's Ameren's fault, not mine. And they will try to shift that liability to you. They will try to share that liability with you. Very important to get something in there that restricts the liability to just Ameren. And then finally, I've seen, these are just some examples I've seen quite a bit. I've seen easements that I refer to as blanket easements. And it's somewhat similar to the access discussion we had earlier, where the easement itself is articulated to you as if it's only to a 2-acre portion of your property. But if you read the easement, it actually applies to all 4 corners of the property. But not only beyond the access component of it, if you do sign a blanket easement, and that's what these are called, blanket easements, they blanket the property, many times there's also a clause in there that allows Ameren to come in and add more lines, or even sell their area within the easement to a pipeline or a cable company or another utility company. And so that they then basically sublease the easement to another entity, so they get money from their sublease of their rights to another company. You don't get any of that because the Ameren is the one that's selling their rights. And then that company comes in and throws a pipeline in, and maybe throws another power line in, and goes next to it and outside of what the easement presumably was supposed to be. And that's because it's a blanket easement that applies to every corner of the property. And not only that, the easement itself also allows for adding power lines, adding pipelines, all of these things. This is what happens. This is what the easements say very often. I have seen Ameren easements that have this language in there, and I haven't seen them. This is our first venture on this project specifically. I haven't seen any offers yet, but I'd be interested to see if they're still up to their same tricks with acquisition on these parcels. So, and I'm going to give an example, and then we'll move on to money. I talk about these potential pitfalls, and a lot of people think, well, that's going to happen in the future, or it doesn't really concern me, and what's it matter? They build it. What are the odds they're going to come in again and do anything? And by then you'll be deceased, or you'll have sold the property, and what do you care? And my response to that is always to remember that, first of all, easements are forever. Easements are not like leases or farm leases, as an example. It's not a contract with a limited term. They last forever. The document is signed by the parties, recorded at the county recorder's office. It becomes part of the property's record. If you were to sell the property, the easement shows up. If your children were to inherit the property, they take the property subject to the easement. It is, unless the easement is specifically extinguished by a separate document, it lasts forever. And what comes with that is that ancient easements signed a long time ago, become modern easements. And what you sign will become whoever takes the property's burden. I talked about blanket easements. I want to give an example. About what was it, 6 or 7 years ago, we were marketing to a utility project, and it was the installation of additional pipelines. And it was called the Southern Access Pipeline Extension, and it was an Enbridge project. And we marketed just like we market to you guys today. And I started to get copies of these easements, or copies of the offers that were made. And then I looked at some of the property records that were provided, and it would seem that back in the 40s, the Sinclair Oil Company went out and bought a bunch of easements for their pipeline that was, I think, a 10-inch pipeline 60 years ago, 70 years ago. It was in the 40s. They built it, they installed the pipeline, and then nothing happened on the easement for decades. The pipeline was there, everyone had moved on, died, the property transferred hands, so on and so forth. And it just sat there doing its thing, transmitting the oil, and then no one thought the wiser. But what happened a couple of years ago is that Enbridge got a hold of these easements. They bought them. The easements were bought and sold from Sinclair to Amoco to Shell to so on. And eventually they ended up in Enbridge's hands. So Enbridge held these rights that were signed back in the 40s. And what did they do? They want to build another pipeline right next to the one that was laid 70 years ago. And so what did they do is they went out to all of these landowners whose ancestors, whose parents, grandparents signed these easements 70 years ago, and they said, okay, we want to put another pipeline in, and we're going to start next week. And the landowner said, well, no, you're not. You don't have the right to do that. I haven't signed anything, so on and so forth. And Enbridge said, look at your property record, look at your title, and you will see that there's an easement on there from 1947 that that was bought by the Sinclair Oil Company that we now own through assignment. And if you read that easement that was signed 70 years ago, you'll see that not only did it allow the pipeline company the right to one pipeline, two, three, as many pipes as they'd like, installed whenever they would like, wherever they would like, across the property. It was a blanket easement. These were signed for pennies on the dollar 70 years ago. Well, what happened is in 2019 or 2018, whenever this was, they got a hold of these easements and they didn't have to pay the landowners anything because they already had the right to add as many pipes as they would like because it was already negotiated 80 years ago. This is an example of what can happen is you sign a bad easement, property gets inherited, and all of a sudden the company comes back and they want to build another line. And whoever inherits the property, whoever buys the property has no right to stop them because they already had the right through the original easement. Long story short, easements are incredibly important to be crafted appropriately. Ensure that you have somebody take a look at it at the very least. Okay, so moving on from easements, we're going to talk about money, the other big component of your negotiation with Ameren. And what I've included here is what I consider a complete compensation package. And a complete compensation package should include a proper price breaker for the land to be acquired. It should include a proper payment for crop damages for up to 5 years, possibly more, depending on the property. The payment should anticipate soil and ground damages, or there should be a clause in the easement that requires Ameren to remediate. I ran into a big deal on this on a pipeline case in St. Louis. Pipeline cases in St. Louis. The pipeline came in, built the property, destroyed the ground, threw the soil back on haphazardly. Crop damages are low. Flooding, ponding occurs now on the property because there's dips and low points in the land. They hold water, they pond, all these things. These can happen on power lines just as well as they can happen on pipelines. So it's important that you have an apparatus that makes them pay for it, or they've already paid for any anticipatory restoration issues. Other factors that need to be considered. All damages, either prospective or that require payment when they occur. Field tile, irrigation, compaction, soil mixing. They'll leave debris out on the farm. I've seen it before. They'll bury debris. Just tools and various metal scraps. Those will end up in your soil. I've seen that before. You need to make sure that they remove that, or they pay for the removal, or they pay you something. Flooding, if they build this thing during water season, they start shooting water off the easement onto your property because they need to clear the right of way to build it. There needs to be something there that says that you can't do that, and if you do, they got to pay for it. Residual damages, that needs to be part of it, and we will talk about that in the next slide. But basically, what that is, the impact on the rest of the parcel that the easement has, the impact on the value. And again, we'll talk about that here in the next slide. And this is all in addition to any bonus payments that Ameren might offer. In our experience, Ameren sometimes offers bonus payments, 10% bonus or whatever, in order to get you to sign. This is and we'll get to this in the right of way slide, but a quick response from a landowner is usually a bad one. And Ameren knows that. They would like landowners to make quick decisions, signing documents, not asking questions, not getting second opinions, because the more analysis you perform of the documents, the more issues you're probably going to find. And Ameren knows that. So a quick decision without an attorney is what Ameren wants. They want you to do that. So keep that in mind. That's why they offer the bonus payments, is to get you to make a quick decision. So what's residual damage? I said we talked about a proper compensation package. It should include residual damage. Residual damage, put very simply, again, is the impact that the introduction of in this case, a power line, the value impact that has on the rest of the parcel. And a very easy example is what I presented before you. So you have two parcels, let's call them identical. Same soil, same productivity, they're right next to each other, same size, everything. They're both 100 acres. One has a power line, one doesn't, okay? On the open market, as the argument goes, the one that does not have the power line will go for more than the one that does. Now, this concept is basically known as stigma damage, in that effectively, if given the option, farmers and people would generally not like to live next to power lines. They would not like to farm next to power lines. They don't want to deal with the poles. That can affect farming. It can affect farming efficiency. And there's also perceptions of power lines. People have beliefs that that they can cause cancer, that they give off electromagnetic pulse or what have you. All of these things that have been part of the lore of power lines for, as long as they've been around. I characterize them as stigma, the stigma associated with power lines. Whether they are true or not, it ultimately doesn't matter. The argument goes that people pay less for properties with power lines versus ones without. And that is the difference between those two parcels is residual damage. What is the impact because of the introduction of the power line? And the impact varies. It depends on where it's going through the parcel. Is it bisecting it? Is it going along the property line? Where's the property being farmed? All of these things factor into this residual damage. Long and short of it is that, especially if this is a new power line and they're not just adding or replacing an old one, it's important to get residual damage compensated for. And so here's an example of negotiations and how it usually goes. And this is why Ameren loves to have discussions about price per acre. If they come out to you and make you an offer for $13,000 an acre, disregard these numbers, by the way. But if they come out and make this offer, the initial response is, of course, to say, well, no, my land's it's not worth that, it's worth this. And because most landowners, most farmers can, ballpark their land's value, if not know it, or believe to know it. And they might respond and just start getting in a land comp battle, battling over price per acre. This is an example of that. The right-of-way agent says it's worth 10. You say this is incorrect. It should be, let's correct that. I changed the numbers. So if your land's worth 10, your response says no, it's worth 11. They split the difference, give you 10.5, and applying the $500 increase, it's only $2,000. This is a discussion that Ameren would love to have with all of you. Once you start only talking about price per acre, Ameren has already won, because then you're not talking about crop damage, you're not talking about soil damage, you're not talking about restoring the land, you're not talking about residual damage, stigma, all of these things. They don't want to have that discussion, and I'll show you why. They want to have this discussion because even if you quibble over $500 on a 4-acre acquisition, you're talking $2,000. That's not a lot of money, and Ameren will have that discussion all day with you. Now that's how Ameren wants the discussion to go. How the discussion should go is, okay, the right-of-way agent says, let's talk price per acre. You say, no, let's talk about residue damage. I want a 10% impact on the figure of my on my parcel. And for a 100-acre parcel, it's at $8,000 an acre. Again, disregard the numbers. That's an $80,000 difference. They don't want to have the $80,000 discussion. They want to have the $2,000 discussion. They don't want to talk about residual damage. They want to talk about price per acre. These are the discussions they want you to have. These are the discussions you should have. And that is how they get you. Let's talk about other land agent tricks. And land agents are the people, the right-of-way agents. These folks are professional buyers of property. Their job, whether they work for contract land staff or some other right-of-way company, their job is to get your land. And they get paid for every parcel they get. So keep that in mind when you're talking with these right-of-way agents. They start telling you things, start making promises and saying this and that, is that they don't have your interests in mind. They have their interests in mind. They have Ameren's interest in mind, and that is to get your property as quick as possible and as cheaply as possible, and with the most favorable easement language they can get as possible. So keep that in mind when these folks come out to you. And remember, these folks are professionals. This is what they do for a living, and they have all sorts of crafty ways of going about doing this and getting folks to sign on the bottom line, sign the easement, and get that parcel wrapped up. These are just some of the things we've seen. They'll say they're offering you 125 or 150% of fair market value, as if they're giving you a deal. But again, according to whose opinion of fair market value, and what does that even mean? Is it the appraiser? Is it the land itself? Is the easement? This is and again, this is a discussion of price per acre, which. So you're already having a discussion believing that they're giving you a deal. And on top of that, you're not talking about residue damage. They'll do this. Bonus payments. Again, these are offered in an effort to make it seem like they're giving you a deal. That they're saying, hey, not only are we going to give you this land value, we're going to give you money, additional money, just to be nice. Not how it works. And that's again, another trick to get you to sign the documents. Crop damages. These are things they owe regardless. If they damage your crops, whether there's an easement there or not, if anybody damages your crops, they're responsible for paying you for them. So when they offer you crop damages for what they're going to do, this is what they already owe you. They just haven't done it yet. So keep that in mind. Again, these are offers to make it seem like they're doing you a favor, that they're looking out for you, or they're probably going to help you out. It's fulfilling an existing responsibility that they already have. The shell game. I refer to the discussion about price per acre versus residual damage as a shell game. They want to talk about price per acre under this shell. They don't want to talk about residual damage under this shell. They want your attention on price per acre. Remember, you have leverage as a landowner. Ameren wants your land. They can't get it. Not yet. They will eventually, but they can't right now. So keep that in mind. You have leverage. Your ability to tell them no is your leverage, at least right now. Now, eventually this leverage runs out, and that's when they get to eminent domain and they take it that way. But we're not there yet, and you have time. And they're not going to be able to sue until next year at the earliest. So keep that in mind. Your ability to say no gives you leverage. Watch out for verbal offers. I've seen offers that are done verbally, not written down. That is not helpful and is not worth the paper it's written on, as the old saying goes. They'll try to do this. They'll show you numbers and they'll take them with you. They'll write stuff down and put it in their pocket and they'll show it to you, and all sorts of things not to commit to actual terms and actual compensation. This is it's unprofessional. It's not what you as a landowner should have when relinquishing your property. You're entitled to written offers that spell out exactly what you're going to get. I've seen offers that say they're going to go up, they're going to go down. These are all efforts to get you to sign. I've seen folks say, if you don't take this, you're going to get nothing. I've heard that quite a bit. If a right-of-way agent tells you, if you don't take this, you're going to get nothing, unless you already have an easement on the property that gives Ameren the full right to do what they want to do, you're going to get something. Your land is worth something. So a lot of times right-of-way agents will use eminent domain as kind of a threat. They'll say, listen, if you don't take this, you're going to go to eminent domain, you're going to get nothing. I hear that all the time. It is a lie. It's not true. And if anyone says that to you, the first thing you should tell them is say, okay, we're done here. I'm going to contact my attorney. Okay. They're lying to you by telling you and scaring you into thinking eminent domain is a scenario where they take the land and you get nothing. That's not how eminent domain works. You're entitled to just compensation at court, and they don't get to determine your compensation. So if they say that to you, red flag should go up. Okay. Now, the rest of the presentation is largely going to be about hiring an attorney. I can only speak for our firm and how we operate. Can't speak for other attorneys, law firms. But the way our firm works is on a contingency, and this allows us to represent clients without landowners coming out of pocket. I tell folks that there's only one check that's written in our relationships with our clients, and that's from us to you at the very end. Meaning you don't have to send me a check for any amount of money for me to represent you. You don't have to, I'm not going to bill you every month. We don't bill at all. The way we work is our fee is contingent on how much more money we get for you. So a very easy example is the one we're looking at right here. Say you're offered $10,000, we get you $50,000. In this scenario, we added $40,000 to the case. Our firm gets a third of the $40,000 we add to the case. You end up with that. And in addition to this, we also review the easement. So our representation is twofold. We review the easement. We ensure the wording is correct. We also negotiate compensation over and above what is offered by Ameren. And so you don't pay me separately for the document review. The document review is part of our fee that comes out at the end of the case whenever it's resolved. One question I get is, what happens if we hire you and you don't get us any more money? And if that happens, then I don't get paid. So in this scenario, it also doesn't generally happen because we don't take on cases that we don't foresee recovery from. But let's say that happens in this scenario, this $10,000 offer scenario. Let's say you hired us and we couldn't get you another dime. You would get the $10,000 that was originally offered. We wouldn't collect a fee, and that would be that. So if you're interested in a different arrangement, we can talk about that further, but this is the one that most folks appreciate and work with us on. Moving forward, what I tell folks is, as soon as you receive an offer, you should be hiring an attorney. But until that point, so I'm sure you've had maybe some letters from Ameren, maybe some survey requests, things like that. When you start getting those letters that are just preliminary contacting, that's when you should start considering your strategy, what is important, what's not important. Maybe start vetting attorney options, seeing what everyone has to offer. But that's prior to the offer. Identify your priorities and your goals, and then once you get the offer, you present it to the attorney, and the attorney gives their assistance. So for our firm, what I tell folks is, if you have an offer, first of all, I am 100% willing to review it for free. That's we offer that as a matter of course. I reviewed hundreds, thousands of offers. It's part of my job. I have no problem doing it with yours. And the reason why we like that is that if you come to me and the offer's great, let's say the offer's, the blind squirrel found the nut, and the offer is everything you could want and more. And I'm going to say, this is a good offer, because I wouldn't tell you that if it wasn't the truth. If it was a bad offer, I'd tell you that because I'd want you as a client. If it's a good offer, I'll tell you, I'll say, listen, this is as good as it's going to get. The easement looks fine. Maybe go forth, do what you need to do. Good luck. That'll be that. No bill or anything like that. So, that's how we operate. Feel free to send me these offers, and I'll look at them for free. And then going back to our experience real quick, this is what we do, to put it simply. I referenced the Ameren Illinois Rivers Project. We've already gone against Ameren. We represent dozens of landowners. We had a great result for all of the landowners. They all got more money. Some got, double, triple the offer. Everyone came out ahead on that. The Spire STL pipeline, again, this is a recent one. It was a couple of years ago. This was in Illinois, Missouri. We represented dozens of landowners on that. Again, everybody got more money. Some people doubled, tripled their offer. It was, again, another good result. And then the Grain Belt Clean Line we're currently working on. We represent, again, dozens of landowners in Illinois. This is another transmission line going across the entire state. Bigger, I think it's bigger voltage than this, but regardless, a big line that we represent several folks on. Okay, and this is going to be my final slide, and then I'm going to open it up. I'm going to take a look at the questions. I'll answer what I can, and then we'll take more questions if we need to. What I'll say is that if you have the ability to form a group with your neighbors, if you're all affected, that is crucial. It's huge. If you can, I said earlier about leveraging your position. The easiest way to leverage your position is to say no to the first offer, or tell them that you're going to review it and then hire an attorney. The second way to increase your leverage in this scenario is to create a group. And groups, I mentioned them previously in the other projects. Groups can be as simple as being represented by the same attorney. You don't necessarily need to know everybody, but if one attorney represents, 60 landowners versus one attorney representing 5 or 6, or just a one-off here and there, the 60-person group by its size will have more leverage than the individually represented folks. You'll be able to, that's how it works in the scenario, is that if I go to Ameren and I say I got all these folks signed up, and they're going to listen to what I say regardless, but they're going to realize the reality is that this project is going to get more difficult for them. It's going to get more expensive for them, and they're going to not get what they want if they don't work with me and my clients. That's the reality of the scenario, and that's what we want to do on this project, just like we do on the other ones, is create a giant or a big group of folks that we all represent that still all have their individual cases. I should state, this is not a class action scenario. Everyone has their own case, but it's the power of the group. So if you have a group of landowners, that's great. If you just want to sign up with our firm, you would automatically become a part of whatever the size of the group we ultimately get is. So that's an added bonus. If you have an offer and you want a review, you can email it to me, jordan@landownerattorneys.com. That's my email address. You can text it to me. You can text me. So at 470-869-1383. Or you can fax. This is our fax number, 317-575-9943. All I need is the easement, the monetary offer, whatever that is, whether it's usually a one-page sheet, and then a map that depicts where the route is going, where they're putting the line. That's all I need. And you don't even need to introduce yourself. Just send it and say, well, you can tell me who you are, but you can just send me an offer. You don't need to say, hey, can I send you an offer? Just send it, and I'll look at it, and I'll respond, and we can set up a time to call to talk individually, and we can talk about the issues. Okay, so I threw a lot at everybody. I'm going to see if there's any questions. It doesn't look like we have any questions, but I'm going to give everyone some time. There's a hand raised. Carmen, can you go ahead and type the question? I don't think we're going to be doing verbal questions, so if you can just type it, and then I'll answer it. So you don't need to raise your hand. If you have questions, just go ahead and put them in the Q&A or in the chat box. You'll see at the bottom of your bottom of the window, you should be able to do that. Okay, we got a question. All right, let's take a look. Okay, so this is a question. Should we sign the right to entry? So Ameren is coming through, and that is what I presume to be the survey permission, the survey permission form. Ameren has the ability to survey. They have it via the ICC petition and under Illinois law. So what I tell folks is, and that's the right to entry. Basically, Ameren needs to come in and survey the property. You can either grant them the right, or they can seek that right, or they'll try to do it from the road if they can. But if they absolutely need to come onto your property to do it, they'll get a court order to do so if they need to. So what I tell folks is, they can do it if they want. So the question is whether or not you want to be present for it so that you can monitor, what they're doing out there. And if they damage anything, they are 100% liable for that. So keep that in mind. So some folks would like to be there. They'd allow the right to entry so that they can arrange to be there so that nothing happens without them being present, because they might just come onto the property on their own. So that's what I tell folks with regards to the right of entry. It's ultimately up to you for what you want. They do have the right to do it. So fighting it will only get you so far. It might be a better choice to just, not necessarily accommodate, but be present if you want to see them, see what they're doing on your property. Next question: can we fight the project? Okay, so I do want to say one thing, and I didn't say it at the beginning. We are not here to stop people from fighting the project. If you don't want this project to happen, by all means, exercise your rights, try to stop it. What I would tell you is that the time to stop the project, stop it altogether, is now. You want to participate in the Illinois Commerce Commission proceedings, okay? And that means filing an intervening petition, be part of the docket. You might testify. You might want to do this, voicing your opposition to the project. If that is what you want to do, should happen now at the Illinois Commerce Commission stage of the process. We are not going to be doing that on behalf of landowners, only because in our experience, fighting these projects is very difficult. Especially with Ameren. If this were a different company, I would say that the fight might be a little bit more balanced. But ultimately, if Ameren wants to build this thing, and they are committed to it and they follow the procedural requirements, they're going to be allowed to build it. Now, if you want to push it off your property, you can intervene and try to push it off your property. Now, at the ICC, when they come through and they make the offer, you can always tell them, hey, we don't want this on our property. You can maybe negotiate it away. If you're represented by counsel, they might say, well, we don't want to deal with this landowner because he has an attorney and the neighbor doesn't. So we're just going to push it on that guy's property or that person's property as well, or instead, and do it that way. That's a method to fight it. And then you can always try to negotiate your way out of it. Like I said, you can put up such a fight that they don't want to deal with you and they might go to the neighbors. One thing to consider on all of this is that, and I tell this folks a lot. Let's say the power line is going right down the border of your property, and you don't want it on your property, and you say, okay, I don't want it. Put it on the neighbor's property. And you might get what you want, but it might not be what you actually want, because then they'll just push it on the other side of the property line. You'll still have to stare at it. You'll still have to see it, experience it effectively. It'll just be moved over across the property line, but you won't get any money for it because it'll just be on your neighbor's property and they'll get the money. So you're effectively dealing with it. Yes, they're not going to be constructing anything on your property, but you're experiencing a lot of the negative side effects without getting any sort of compensation for it. You don't get paid if they acquire your neighbor's property. So something to consider when you're doing all this is that you might succeed in moving the line off the property, but you might not actually end up wanting that. Now, again, going back to stopping the project, you're going to have to basically say that this is unnecessary, unneeded, for a private benefit. And you're going to have to argue that at the Illinois Commerce Commission stage, which is, again, it just happened. So if that's what you'd like to do, if you want to fight the project, now's the time to do it. Again, we've done it before, but I don't generally like to do it because it almost feels like I'm taking people's money, because it's such an uphill climb for these projects. You have to sink, if you really want to stop this project, you need to pay attorneys. You're probably going to need to pay experts, engineers, depending on what the argument is you're making, and it's going to be very expensive. So if that's something you do want to do, I'm happy to talk about it. It's something that I don't generally advise people to do just because it's such a tough hill to climb, and it's also very expensive. Okay, and then the next question is the existing set of poles staying in while the new poles are being installed? Just curious, and how it's going to play out is how the new poles set. Right now, we have half the easement shared with the neighbors. So that's a good question. That gets into basically the construction processes of Ameren, and what they're going to do on your individual parcel. Um, that's a good. I'm not sure if I know the answer to that question. That's getting pretty into the, that's getting into basically Ameren's process and procedures that they don't generally publish. And I don't work for Ameren. I think that that is a question that I think could be answered on a more individualized basis. So, if you wanted to find out how the construction process is going to work, what are they going to do? That would be a discussion that I would try to accomplish through the right-of-way agent, or if you have counsel, have your attorney, talk to whoever they're talking to at Ameren to figure that answer out. That also is going to be probably parcel by parcel. So it's very difficult to say how they're going to do specific construction on each parcel. I'm sorry, I wish I had the answer for that, but it's kind of a individualized inquiry. Okay. Okay, those were all the questions I have. I'll give it a little bit more time if anyone wants to jump in. Okay. The question is how to get compensated for the long-term damage of my land by the project. Well, the easy answer is to hire an attorney. The way to get compensated for the long-term damage is to include it, or make sure whatever that long-term damage might be is included in your negotiations with Ameren. When you sign the paperwork, it's over. It's done. There aren't going to be more payments unless they damage things down the road. There's one payment. You get it at the beginning, and that's for everything that, whether that is expected or anticipated at the time of the acquisition. So how you get paid is you negotiate it. You make sure that the stigma damage is included. You make sure that crop damages are properly included, to include any potential damages on the property. You include language that binds Ameren to compensate for things maybe they didn't pay for initially, down the road as they might occur. I think the easiest answer is how do I know I'm getting properly compensated is to ensure that you're putting your best foot forward and that you're going in your negotiations with everything, a comprehensive request, a comprehensive demand that includes every possible facet of compensation that you're entitled to and anything that could reasonably be compensated for. That's how you get compensated, is you are comprehensive in everything in your negotiations. You include every possible fact that needs to be included, every term of the easement agreement that needs to be negotiated. That how you do it is you are comprehensive in your negotiations. Okay. Any other questions? Okay. I am not seeing any more questions. So with that being said, I'll go ahead and end this webinar. And before I do end it, I will go ahead and put my slide back up just for anybody who wants to get my information back. But it has been a pleasure. Thank you, everyone, for your attentiveness. Please do not hesitate to contact me with questions that you might have. I'm happy to answer them. Send me an email, shoot me a text, let me know. We're happy to walk you through this as best we can. Thank you again. And again, I will put up the slide with the information. Feel free to write it down. Let's see. And that'll be that. Thank you, everyone. We appreciate it.